We are on the record in CR 2014-00949, 2014-01054, and CR 2014-01772. If I have identifications, please.
Right, Sean Nesvold, Jerry McBride, for the state, along with Detective Middleside.
Good morning, Your Honor. Michael Allers III and Joey Hamby with Law Associated Cadger. Appearing on behalf of Tyler Kost, who's present to my right, he's an investigator.
All right, this is the time set for sentencing. Are all parties ready to proceed today?
Yes, Your Honor.
A few preliminary matters. First of all, there's been a request from media to cover the proceedings here today by still photographs, as I understand it. That's subject certainly to the order I issued back on July 13, 2015. While that coverage is permitted, it's subject to the conditions in that order, including no photographs of any victims and obviously no flash photography in the program. Another preliminary issue in reviewing the defendant's pre-sentence report, there was the suggestion that the defendant, my interpretation from the sentencing memorandum, there was a suggestion that the defendant had not admitted to any non-consensual sexual contact. That gave me some concern about whether there was any issue with the factual basis for counts 14 and counts 26, which I would clearly call for an admission to non-consensual contact, at least of the female breast. So the defense wants to clarify, and please listen carefully, Mr. Kost, as well.
Yes, Your Honor, I can clarify that. And just to be clear, there was no statement made by Tyler himself about that during the pre-sentence investigation report. He didn't make a statement during that at all. So what we are talking about is our sentencing memorandum. It included a sentence that the wording of which was a little bit confusing. Our point was that at the outset of this case, he was charged with several counts that included sexual assault. All of those counts have been dismissed as a result of the plea agreement, and that was our point, is that he did not admit or plead guilty to any of the sexual assault counts. But to be clear, by definition, the two counts involving sex abuse that you discussed do involve a breast touch without consent, and yes, he has made a factual basis to that fact.
And Mr. Kost, you understand that you made a guilty plea for having contact with the female breast with KG and with SD counts 14 and 26. Is that your understanding, sir?
Yes, sir.
Understanding why that factual basis here?
Yes, sir.
So you have anything to add to that?
The state would just formally ask the court to incorporate the three different grand jury transcripts for the factual basis as well.
Any objection to that request?
No, Judge.
Okay, so ordered the grand jury transcripts from all three of the case numbers identified previously will be incorporated into the record to support the factual basis provided for the offenses that the defendant pled guilty to here today. Second preliminary issue, probation submitted a pre-sentence report. In the original pre-sentence report, there was a summary of only one of the counts that the defendant is pled guilty to. Probation has now submitted a supplemental pre-sentence report making clear that they have reviewed the police reports related to the other counts to which the defendant is pled guilty, and that they have considered that information in making recommendations. They're standing by their recommendation. Probation has also made clear that they are very willing to have a supplemental pre-sentence report prepared that gives a summary of each of the other counts that were not included in the original report. Let me state for the record, in this case, I don't think I would benefit from that as the judge, because I have reviewed extensive discovery in this case that far exceeds any summary of the evidence that probation provided. Notwithstanding that, our either counsel, the defense or the state, requested the supplemental report be prepared for any reason that would provide a summary of the facts for the other counts that were not included in the original pre-sentence report.
The state is not going to.
No, Your Honor, we're satisfied with the pre-sentence report and the
All right. As I indicated, I reviewed the original pre-sentence report, the addendum. I reviewed the criminal history, more accurately, the lack of criminal history is reflected in the report of the probation. I've also reviewed the state sentencing memorandum and the attachments. And I believe you tackled a supplemental pre-sentence report that has some actions with it.
Correct.
So, in effect, I reviewed that as well. In addition, I reviewed the sentencing memorandum submitted by the defendant, together with all of the attachments to it. Is there anything else in writing that either counsel believes has been submitted to the court that I haven't referenced up to this point?
No, Judge, it sounds like
Any no further matter given the course, particularly of the motion to sever. A lot of information is provided to the court in the form of transcripts, video recordings of interviews, audio recordings of interviews, extensive social media records, and records of text exchanges. I've had the opportunity to review those as well. My understanding is that there may be some witnesses here, both from the state and the defense, that wish to be heard. Mr. Henry.
Thank you, Your Honor. We'd ask to call a couple of family members and friends for Mr. Kost to speak. If the court would allow, we'd ask to start with his great uncle and great aunt, William and Nancy Kost.
All right, and just to be clear, I'll hear first from the defense witnesses, and then I'll hear from the victims so they have the opportunity to respond to anything that was said. If there are any state's witnesses other than victims or victims' representatives, I would like to hear from them first. But if my understanding is there's only victims or victims' representatives that wish to be heard here.
That's right.
Okay. All right, so under that understanding, Mr. Handy, if you want to have them come forward. And are all parties agreeing that they can just make a statement, not be sworn, subject to cross?
Yes, sir.
Yes, sir.
Okay. Good morning to you. If you could identify yourselves for the record and then tell me what you think I need to know.
I'm Bill Kost, William A. Kost, full name. And my wife Nancy.
Nancy E. Kost, great aunt of Tyler Kost.
Again, good morning to both of you. What do you think I need to know?
Okay. My wife and I, who are Tyler's great uncle and aunt, and my 96-year-old father's seated in the wheelchair back here, he's Tyler's great grandfather. We stand before you today to share what our lives have been like without Tyler for the last 1,017 days. I need to share a bit of background with you first. I'm the youngest brother of a set of identical twins. My brother, who is Tyler's grandfather, grew up in a very close family surrounded by aunts, uncles, and grandparents on a daily basis. My brother and I were the first in our extended family to graduate from college with engineering degrees and then continued on with and obtained our master's degrees. My brother and I worked for and retired from the same company after 45 years of employment with the Nevada test site. We were raised in a strong but very loving family and have brought up our children up in the same environment as we were raised. Family is very important to us. When Tyler's grandfather, my twin brother, was diagnosed with a disease that only a heart transplant would help, my wife and I, along with my father, who lost my mother in 2010 after 69 years of marriage, chose to uproot our life in Las Vegas and relocated to be the support system for our family in Arizona. We made the decision in 2013 to move to Arizona. We built a home pool to accommodate our extended family and look forward to spending time with Tyler and the rest of the family. We look forward to watching Tyler and his brother playing baseball in addition to officiating sports, an interest he had in common with his grandfather and myself, who had officiated sports over 25 years, or watching Tyler walk down the aisle to receive the diploma of honors as an honor student. But Tyler was ripped, torn from our family in April of the same year. For the last 1,017 days, we have been a complete family. We've come to celebrate milestones or occasions with Tyler, if you can call it that, by conveying information by video chat, phone, and by mail to Tyler those important events in our lives. Tyler's life has been forever changed. Tyler's grandfather, who survived his heart transplant only to lose his battle with cancer in May of last year. His death had to be conveyed to Tyler over a video chat. We've lost more than 1,070 days with Tyler. We've lost celebrating those achievements he worked towards in school, honor students, sport achievements, and so on. The joy in his face when he umpired a game and simply spending time with family. Tyler has served his time behind the walls and bars of your jail, and he will continue to live with the outcome decision of this court for a very long time after he leaves the jail. We are a strong, loving, caring, caregiving family. Our faith and beliefs have been tested time and time again these past 1,017 days, but we will all heal from this nightmare and try to make up the time we've been apart from Tyler. But we can never celebrate his high school graduation, the birthdays, or holidays we've missed. We can only look forward, and forward we will. Tyler will make up for the lost time. He will get his high school diploma and then get his college degree. The young man will do great things in spite of this. As I said earlier, Tyler has a strong, loving, caregiving family and a strong support system. He is the son that every parent would want their son to be. He has the full support and love of his entire family to help him through the days and years to come. Please allow Tyler's 1,017 days in your jail to be his time served, and let him come home and to his loving family. Thank you, Bill and Nancy.
Thank you. Good morning.
Good morning. My name is Carrie Conley. I met the Kost family when I was in middle school, and they've been my closest friends for over 30 years. I can still remember the day Tyler was born. He was perfect in every way. I watched Tyler and his brother grow up. We've shared birthdays, holidays, and every milestones. I have a daughter who is 17 years old. She's like a sister to Tyler and his brother. I also have a 13-year-old son who looks up to Tyler in every way. Tyler is everything I hope my son grows up to be: intelligent, compassionate, loving, respectful, and someone who genuinely cares about people. The love Tyler has in his heart and the willingness to always put others first is a quality you rarely find in individuals, especially teenagers. I've been on this journey for the past 3 years with Tyler and his family. I communicate weekly with Tyler via the iRub system, and it never ceases to amaze me how positive he has remained throughout this process. Tyler continuously makes me look at life differently. He is a beautiful person who has helped me to look deep into myself and see that there's still good in people. Tyler is a joy to know, love, and I'm proud to be a part of this life. The support system he has in place to help me move forward in life is nothing short of incredible. I stand before this court and ask that you allow Tyler to come home and be with his family. Thank you.
Thank you.
Morning, Your Honor.
Good morning.
My name is Richard Kost. Alongside me is my wife, Rebecca Kost. And Tyler is our nephew, as well as my godson. Personally known Tyler his entire life. I love him as I would my own son. Tyler has always been respectful and caring. I've witnessed firsthand how he was there for his mother and the family as his grandmother's health slowly deteriorated from Crohn's disease and eventually passed away. His sense of caring for his community also shined bright as an umpire for Little League. As a former umpire and official myself, he would always come to me for advice on how to improve. He wanted to make sure he was doing the best he could for the community and for the integrity of the game. Over these past 21 years, I've had the pleasure of watching him grow and show great promise, not only as an athlete, but as an academic. As an uncle, I'm very proud of him for the numerous times I could watch him accept awards for his academic achievements in school, or see him pitch for his baseball team. We are standing here before this court this morning with the understanding that Tyler has made a mistake. He has taken responsibility as a man for a misstep he made as an adolescent. Tyler has missed out on so many things over the past few years, including the passing of his grandfather, my father, a time which he will never get back. The opportunities of scholarships for college, along with his dream to serve his country in the armed forces, these have also been taken away from him. Tyler has a wonderful support system between family and friends that are always going to be there for him. This support system will help him to learn from this transgression and move forward in life. We humbly ask the court that you take into consideration this information when determining Tyler's sentence. And we thank you for the opportunity to speak in front of you today, Your Honor.
Thank you, sir. Thank you.
Good morning, Your Honor.
Good morning.
I had to write this down, so I apologize. First, we'd like to thank the court for allowing us the opportunity to speak here today. April 21st, 2014 was the last day that I recall seeing my wife of 23 years smile unconditionally.
Mr. Kost.
Yes, sir.
If you just have to identify yourself and your wife and yourself.
Absolutely. My name is James Kost. I'm Tyler Kost's father. This is my wife, Angelique Kost. And our son, Tyler's younger brother. I'll say CK, if that's okay.
This one. I apologize for the interruption.
No worries. It was a happy time for our family. We were planning Tyler's graduation and making decisions on colleges and his future, doing the things that most families do with their children while they're preparing for the next chapter in their life after high school. As parents, we have instilled positive values in both of our boys. Tyler spent his early childhood attending a Lutheran school. He was active in adult sports, played baseball from T-ball through high school, which I coached many of his teams as an assistant or a head coach. He was raised always putting others before himself and to live life by the golden rule. This was abundantly evident when Tyler was a member of National Honor Society in high school. In the fall of 2013, Tyler chaired a committee with the purpose of organizing a fund run to raise money for the first responders. If you'll recall, just a few months prior, Arizona tragically lost 19 firefighters in the Yarnell fire. Tyler felt compelled to find a way to give back to first responders for the sacrifices those individuals and their families have faced with daily. Unfortunately, Tyler and his committee were not able to see the event all the way through to fruition, but the gratitude of the experience was something we will always be proud of, as will he. Our family has always been very close and active in Tyler and his younger brother's lives. Whether it's making sure that we sit down to dinner together every night, where prayer is said by both the boys before our meal, or attending curriculum night at school to celebrate their progress, or simply going to the boys' baseball and football games. We have always participated as a family and supported each other through the good and bad times. Fast forward to April 22nd, 2014. Our lives would be forever changed as we were blindsided with an agony that we wouldn't wish on anybody. We were served with a search warrant and a brief explanation as to what was going on. A couple short days later, we were living out of a hotel with every major media news outlet camped outside of our home, while our dog remained inside for a day, defecating throughout the house out of fear and anxiety until we could ultimately get to her. From that day forward, life took on a new meaning for our family. The simple things, such as sitting down to dinner as a family, were no longer something we experienced together, as a member of our family is now sitting in jail. The simple things that we typically took for granted, such as going to the grocery store, had a new normal. Having to plan trips to other stores outside of our community for our own safety. Death threats were posted on social media with maps to our home. Our younger son had to be pulled out of school and homeschooled for the remainder of the school year, and that was just the beginning. For the past 1,017 days, our family has experienced the loss of Tyler's great-grandmother and his grandfather, my dad. Tyler was very close to his grandfather. Unfortunately, Tyler wasn't able to give his grandfather a hug to tell him how much he loved him and simply say goodbye before he passed away. Angelique and I were left with telling him over a video recorded call, only to have him break down in tears without having anybody there to simply give him a hug or console him. This was absolutely devastating to Angelique and I. Tyler began this journey barely past his 18th birthday as a senior in high school and was placed into a very real adult world. Having said that, we never truly know how we can handle something until we are left with no other choice. Since Tyler's arrest, he's remained positive and helpful to others coming and going out of the detention center, consistently trying to help his cellmates as they would come and go like there was a revolving door, all while he continued to wait. It's amazing how much you can learn about a person and their character in troubled times. As parents, you always pray that you raise your children to do what's right, but when you hear the positive stories of their actions when you can't be there for them, it's a blessed feeling. You see, Tyler was arrested and broadcasted all over our great nation and the world in an incredible game of telephone for people to cast their opinions and judgment without really knowing who Tyler is. Tyler is the 18-year-old kid who celled with a gentleman who was prior military and had PTSD. It wasn't uncommon for the jail to conduct searches utilizing flashlights in the middle of the night. One night, a search was in process, and Tyler was awake in his cell prior to the search. Knowing his cellmate's condition and how he reacted to the flashbangs, Tyler woke him up, had him get down in the corner of the cell, and held him while covering his ears just to reduce the impact of the noise and keep his cellmate from having a negative reaction to the search. True character is measured in times like these, and Tyler's true character showed at that very moment. Education. Education has always been an important part of Tyler's life, and he excelled in school. Since Tyler was removed from high school weeks before his graduation, he wasn't allowed to graduate from Post and View and celebrate his scholastic accomplishments. Unfortunately, once he was in jail, the opportunity to at least finish his education was not an option. So, Tyler read. He read over 140 books, many of which were 400 to 500 pages long. He took whatever classes that were available to better himself and learn what he could while passing the time. He didn't get frustrated or angry, but rather made the best of a very dismal situation. Your Honor, for 1,017 days, Tyler's family and friends have been here to support him. We've been at every court appearance. So many now that I think all of us can safely say we've aged a bit. I know that Tyler has. We are all here to support Tyler for the next chapter in his life. He has grown from this experience and will want to do something incredible with his life, I have no doubt. Judge, Tyler's a good kid, and we ask that you allow him to come home to his family and let the healing process begin for everybody.
Thank you. Mr. Henry, all right, witness wish to hear this?
Judge, Mr. Jensvold and I kind of split the victims in this case. I'd like to present the victims that were assigned to me first. I have two letters to read, or statements to read, from victims that could not be here today. And then another victim, LP, would like to address the court. And then I have some brief comments, and then I'll turn it over to Mr. Jensvold, if that's okay, Judge.
That's all.
Judge, this statement was emailed to me by victim KG on February 1st of 2017. I'd like to read it now. The impact my sexual assault had on me was devastating. My life changed forever. I didn't sleep for months. I had nightmares, and to this day, a few years later, I still get nightmares. I became extremely depressed to the point I was physically hurting myself, and I ended up in a mental health facility for 3 weeks. A month after it happened. I was getting flashbacks all the time. I would start crying in school because of them. I couldn't focus on my work. I was also getting bullied. I was pushed into walls in the hallway, called a slut, and many people called me a liar. I had to spend the remainder of the semester my freshman year in on-campus suspension so no one could get to me. However, that didn't work, so it got to the point where I had to completely drop out of school altogether. What happened to me will stay with me for my entire life. This is something I will have to learn to move on from, but I will never forget it. It was a big relief the day I got a call from Jared saying Tyler took a plea deal and pled guilty. I felt I was never going to be able to get past this until he confessed that he did it, and that's the closure I needed. I want to thank the team of prosecutors and my victim advocates. They really helped me get through this, being there for me along with the support of my family and friends. Thank you. Signed, KG. Judge, I have another statement here from victim abbreviated RH. She is present in the back of the courtroom, and I'd like to read her statement now. I was going to write something about what happened to me and what it did to my life, but I'm going to keep that between me and God. I was 14 when Tyler did what he did to me. He took advantage of how young I was and manipulated me into thinking what happened was my fault. He told me God will never love me and my parents will never forgive me. I believed him. I hated myself because of this. I kept it a secret, and I think that may be the worst thing I could have done. It made me bitter, and I instantly pushed my family and God out of my life. This all led me into a very destructive lifestyle. I didn't care about anything. My heart was so full of hate and guilt, I didn't have room for anything else. I forgot how to love, and I pushed away anyone who even tried to love me. To this day, I struggle with all these things. But Tyler, no matter what I did or how I felt, my parents never stopped loving me, and God only knocked harder for me to let him in. I want you to know that you were wrong. My parents have been right by my side, helping me through the ugliest, darkest things. They constantly point me back to God because he is the answer to everything. Tyler, I pray for you. No matter what you have done, God still loves you. This will be something I struggle with for the rest of my life, but God's love never fails. It never gives up, and it will never run out. Signed, RH. Judge, victim LP is here. She would like to address the court.
Good morning, and you can begin whenever you're ready.
It's up. I vividly remember the day you changed my life forever, and I wish on every star that I'd finally be able to forget it. But for now, I hope this will bring me the closure I need. I remember consistently trying to speak to you, saying anything. Your little brother was in the upstairs sitting room outside your room and was watching me annoying with orange. He kept saying, "Come watch it." It's so funny. I remember thinking how annoying I was and I hated it, but I laughed because I thought maybe he would let me continue to watch it with him because I seemed to enjoy it. You didn't. You took me back into your room. I kept trying to escape, and when I finally did, I ran into the bathroom to call my mom to come and get me. She asked me, "Already?" I said, "Yes, as fast as you can, please." Then I sat there trying to figure out how to get through the next 20 minutes waiting for her. When I was finally leaving, you said, "Don't tell anyone about this." And to be honest, I never had the intentions thinking I would get labeled a whore or a slut. I was going to wait until marriage until you stole that from me. I could have sworn that it was my fault, that it wasn't raped, especially because I went to your house. But eventually I came to ask my mom, "Hey Mom, my friend thinks she was raped, but is too scared to ask her parents." She asked me what happened, and I explained to her what happened to me. She said, "Yes, that's completely rape, and she needs to go to the police." I said, "I don't think she wants to. She doesn't want that kind of attention, and at that age, I probably wouldn't believe her and would just shake it off." She said, "Okay, but she really needs to reconsider that." I left it at that for about a week, and then I couldn't take it anymore. I went to her bawling my eyes out and asked her if she remembered the story about my friend. When she said yes, I told her that it was actually me, and she tried convincing me to go to the police, but it never worked. It took me a long time to get into a relationship, and when I did, it was a guy who respected me the way you didn't. I started to believe that maybe all guys weren't the way you were. I devoted my life to swim in school. I got up early in the morning and went to swim practice, went straight to school from there, and then went right back to swim. I had no time to think about that day, and that was how I healed. Even when I would see you at school, I would be able to shake it off. You would try to talk to me and ask me why I hated you and was so mean to you. I didn't even understand how you could ask such a question. It was days away from graduation. I was literally 2 months away from reaching my biggest goal I ever set in life, to swim in college. I had signed up to college of my dreams and was ready to go. I didn't even want to wait around all summer because I was so excited. There was an assembly, and I overheard something about you from one of my best friends saying that you were in trouble. When I asked why, I explained that girls came forward about you raping them. I held it together until the assembly ended, and then I left. I left school without telling anyone, without any permission, and I started driving home. I pulled over because I couldn't see. I was crying so hard, and I sat there. I asked myself why I didn't go forward when it happened, because maybe they could have caused so much less pain for the other victims. And then I called the police. I knew one more victim would help the case that much more. I went away to college and was there for about a month until I had a breakdown. I couldn't do it. I was terrified of it happening again, and having my family there like I did before. I tried to kill myself because I felt there was no reason to live. The cop came and got me from the town I was in and took me to a hospital where I stayed overnight. I flew back home the next day and thought I would be better now that I was with my family, but I wasn't. I tried killing myself again. I admitted myself into a mental hospital. Usually people spend an average of 5 to 7 days in a hospital like that, but I spent a total of 23 days. The doctors diagnosed me with anxiety and PTSD, which was causing the severe depression. I was then considered seriously mentally ill and put into a program where I meet with a psychiatrist monthly as well as a case manager to make sure that I don't end up back in the hospital. I'm still part of the program and I will be for the rest of my life, more than likely. I take medicine 2 to 3 times a day to keep me healthy mentally. I take medicine to help me sleep because I constantly have nightmares where I'm being raped or this is happening all over again. I was taking medicine for my depression and anxiety. I owe it all to you, Tyler. I wouldn't and still won't go out because I'm terrified of people. I hate going out unless I'm with my family because in all honesty, they're the only ones I have any trust in anymore. My relationship suffers daily from those 2 hours I spent with you. I have 2 real friends and they're from before you simply because I trust no one. Because you and I were friends. We never were flirting, talking about dating, and I didn't even think we were attracted to each other. I wanted friends at my new school, and I trusted you to be that, but you were so much worse than I could have ever imagined. To this day, and for the rest of my life, I will suffer. You are getting a second chance, and I pray to God daily that you don't mess it up. You are so lucky with the punishment you got compared to what it could have been. I want you to know that I believe in change, and that the statistics show that you are the most likely to heal and no longer do this, and that's why I'm coming to terms with your easy punishment. I pray that you can change for the better, and I pray one day I can completely forgive you for what you've done to me, but today is not that day.
Thank you.
Judge, just briefly, I know that this case has lingered around for 3 years. I know that those 3 years were very arduous for a lot of people in this courtroom, on both sides of the courtroom. I want to send a message to the victims that are here today in the courtroom and who couldn't be here today. I think that the better term for them is not victim, it's survivor. And I hope that going forward, they don't let what happened to them define who they are. They are all young, they all have bright futures with a lot of potential. They have many years ahead of them and many things to look forward to. And I just hope that they don't let this ruin that potential and the bright light that they have ahead of them. I know that there will be obstacles. I know that there will be setbacks. I know that this will linger with them forever. and there will be good days and there will be bad days. But I hope that they all overcome what they've faced. I hope that they don't let this define them, because if they let this define who they are, then the offender wins. And I encourage them not to let that happen. Judge, I know Mr. Jensvold would like to say a couple of words, and I know that there's some more people here that would like to address the court. Thank you.
Judge, let me, one moment.
Good morning.
As the saying goes, everyone that comes into your life is either a blessing or a lesson. While you've taught me a tough lesson, I've learned what an abusive, controlling relationship looks like. I am no longer a young, naive, 15-year-old girl. I'm a much stronger person because our relationship has changed me. Just because we were boyfriend and girlfriend does not give you the right to do whatever you want. Yes, sometimes we did have consensual sex, but let me make it perfectly clear to you, your parents, this courtroom, and the media that on November 6, 2012, a 15-year-old girl lost her innocence. A 15-year-old girl was stripped of her pride. A 15-year-old girl was humiliated. A 15-year-old girl was dehumanized. A 15-year-old girl was raped. I used to pride myself on my independence. Now I'm afraid to go on walks and in the evening to attend social events among friends where I should be comfortable being. I've become a little barnacled, always needing to be at someone's side. It is embarrassing how feeble I can be, how timidly I move through life, always guarded, ready to defend myself, ready to be angry. You have no idea how hard I've worked to rebuild parts of me that are still weak. It took me several months just to even talk about what happened. Every time the article in the media would come out, I lived in paranoia that my peers would find out that they were just filming like the girl who was assaulted. I didn't want anyone's pity, and I'm still learning to accept that what had happened to me and not let the word victim become part of my identity. The damage is done, no one can undo it, and now we both have a choice. We can let this destroy us, I can remain angry and hurt, and you can be in denial. Or we can face it head on, accept the pain, and you accept the punishment, and we can move on. Your life is not over. Eventually, you will get to rebuild your life, but right now, you do not get to shrug your shoulders and play the innocent victim anymore. You do not get to pretend that you're set up. We both know the truth, and you sure as hell do too. You think you are untouchable, cunning, and outstanding citizen. I hate to break it to you, but the majority of a high school does not decide to randomly hate a person. There's a reason for it, and you, Tyler James Kost, are one of the most disturbed, sick, demented human beings I've ever met. You have been convicted of violating me intentionally, forcibly, sexually, with a malicious intent. All you can admit to is that it was all consensual, when in fact it was not. Do not talk about the sad way your life is upturned because you decided to do awful things. You plead guilty on one hand, and on the other, you say you're innocent instead of apologizing for your behavior. Figure out how to take responsibility for your own conduct. An apology on your part would be great to hear, but I'm not expecting anything from you. I truly don't think you're capable of feeling remorse for anything that you've done, or to feel empathy for the people you have hurt so deeply. And with that, I hope for once in your life, you tell the truth of what truly happened.
Thank you.
Thank you.
State my name for the record.
Please.
Full name?
Please.
My name is Andrea Richardson. When Mercedes texted me and said she wanted to come home from her father's, I didn't question why. Just got her on a plane a few days later. I was just happy to have my daughter home after 8 long months. I was washing dishes and telling my daughter that my mom said My daughter came home because she was running away from something. I turned around and see my baby girl stuffing Oreos in her mouth. Her face flooded with tears. I sat beside her and held her, and all she could say is, I told him to stop. This is when I realized she was not the same child that I had sent to Arizona. This tragic event changed her for the rest of her life. We got her on antidepressants, which only made her try to commit suicide. There's been cutting. She had to spend 5 days at a charity clarity guidance center. I would drive an hour and whisper lyrics of one of her favorite songs in her ear to me. Mind her, she is perfect to me because she cannot see herself that way. More medications, different counselors and psychiatrists. The self-harm she did was to dull the pain of being violated. She said, no and stop. She has learned to control. The sleepless nights, anxiety, depression, and PTSD continue. Nothing can prepare you to watch your child suffer from something that was not her fault. The argument that this is a conspiracy to get even seems obviously ridiculous when you take a moment to realize how much damage it has caused not only to the victims but to their loved ones. My younger children not understanding why their sister is crying or in a bad mood because the recurring nightmares have robbed her of a good night's sleep for the 4th time this week. In my opinion, as long as the victims and their loved ones are still living with this on a daily basis, the defendant should be behind bars for the personal prisons he has caused us to live in. He raped my daughter. He destroyed a piece of heart that will take us years to rebuild. I have been robbed the privilege of comforting my own child, making her feel safe and making her world a better place. And this is a personal prison I have been sentenced to. Thank you.
Thank you.
Your Honor, as is usual, the victims can articulate anything about what should happen in this case and to reflect the facts of this case much better than I could ever do. But I do just want to point out a few things in here, as Mr. McBride did earlier. As to, the state's hope was that today, finally, the focus on this case would shift to Mr. Kost's behavior rather than this, so-called conspiracy. The state pointed out reasons why you can look at the 13 named victims collectively and clearly see that, but what the victims and their representatives said here today does it far better than I could ever have. Just one aspect of RH praying for Mr. Kost today should just completely wipe out any idea that this was a so-called conspiracy, as has been mentioned earlier. But within the terms of the plea agreement, I think the state and the defense, we don't agree on a lot, but we certainly agree that that was the best outcome for everyone involved in this case. We worked on that settlement conference all day with the 3 judges and counsel, as well as others having input, and ultimately the magnitude of this case, maybe it's not reflected ideally for either side, but it was a compromise that was well struck. And I believe, with all things considered, it is the best outcome for this case. I just want to thank all of the young women and their families here today for the courage that they showed throughout these 3 years. I understand what Mr. Kost's family is going through. I can't fully understand it, but I know and I've seen what they've gone through. And their courage to be willing to testify if this case went to trial was something that should be noted. But as for the plea agreement, Your Honor, the state is not going to take a position within the parameters of the plea agreement as for the term of sentences for the 2 prison mandatory counts, which I believe under the 949 case are amended counts 14 and 26. The state will also recommend that the court not require Mr. Kost to register for amended counts 9, 14, and 26 at this time because the plea agreement calls and the court is mandated to require Mr. Kost to register as a sex offender on the remaining 2 counts, which I believe are remaining 3 counts. I'm sorry. amending counts 5, 6 on 949, and amending count 1 on the 1054 case. This plea agreement allows for Mr. Kost to prove himself. It is the ultimate carrot stick scenario for the 3 lifetime probation tails, 15-year probation tails. This court has up to 45 years in prison hanging over Mr. Kost's head if he violates probation in any way, not necessarily rising to the level of a re-offense. So that is certainly, it's all up to Mr. Kost and his supporters to make sure that he succeeds on probation. And from our perspective, from the state's perspective, for everyone involved, I believe it is in everyone's best interest that Mr. Kost does succeed. There is one position that the state will take today, and it's basically a foreshadowing of a position that may or may not come to fruition, but pursuant to the plea agreement and pursuant to ARS 1381H and 13923, the defendant does have the right to bring a motion before this court before he turns 22 to request an early term of probation or an early release from sex offender registration. That's pursuant to the law because of Mr. Kost's age and the nature of the plea agreement. So the state right now, no matter what happens within the next 11 months, the state will certainly object and will present significant evidence if it comes to that point to object to any early termination of probation or any early termination of sex registration based on all the facts of this case, which Your Honor has seen, including the named victims, including the non-charged victims. 11 months is certainly way too soon to make a determination as to Mr. Kost's ability to perform on probation. He's going to have the state firmly believes that 15 years of probation is appropriate, and he should serve that entire time on probation, on sex offender probation, to prove to this court, the community, and the victims that he is deserving of any early release. Thank you.
Mr. Gensler, you said 45 years.
Well, there are 3 counts for 5 to 15 each.
There are 4 counts right now.
I believe, well, there's a 4th count that is lower. You're right, Your Honor. There's a 4th count that's it's not 5 to 15. It's a lower.
All right, anything else from the state?
Sure.
Can you approach the briefly?
Yes.
Your Honor, as we've discussed in chambers and in status conferences prior to this sentencing here today, it was not the intention of at least the defense to have essentially a mini trial here this morning. That is the reason why we engaged in 2 settlement conferences, why we have 3 very experienced and very well-respected judges come in for those settlement conferences and listen to all of the allegations, all of the evidence, both in support of the state's case as well as in support of the defense case. And this is why we reached the resolution that we have before this court today, is to avoid that trial. Now, I appreciate the state's position. I certainly appreciate the position of the victims who have spoken here today. But I don't want to have to go into a mini trial about specific allegations. So suffice it to say, Your Honor, that I will just point out the fact that we did have a settlement conference in front of 3 very experienced judges in which we provided a binder, and this is an exact copy, with all of the exhibits that call into question much of what was alleged originally in the police reports and much of what the sheriff, Paul Batbu, had stated when he came out publicly and called Tyler Kost serial criminals. That is something that was reviewed by the settlement conference judges. That is something that was reviewed by Your Honor and was attached to the settlement conference. And of course, we attached that as an exhibit and put it under seal to minimize the amount of information that, of course, the media would view and to minimize the impact that this might have on the community and people's names in the police report and not named in the police report. So I would just like to point that out and stand on that and ask that the court take that information that we presented into consideration as an exhibit in this case, rather than standing here today and having a mini trial on some of the facts. Tyler Kost has admitted guilt to the court for certain acts in the plea agreement. He has accepted responsibility for those acts, and he has readily admitted that he has made mistakes in the past. In the end, what this sentencing is really about, rather than having a mini trial, is about the mitigating circumstances and the aggravating circumstances that are present. The acts that were involved in the plea agreement and whether the court should be sentencing Tyler to an aggravated term or to the maximum term, which is before the court here today for the range of sentencing.
Just to be clear, you're referencing the maximum term versus the aggravated maximum.
Exactly, yes. And I think that's a very important point, Your Honor. Is that based on the plea agreement that Tyler has signed, he has already agreed that to the prison range for the Class 4 felony. He has agreed to the maximum term being the floor of his sentence, which is the 3 years in prison. So, what this really boils down to is mitigating factors versus aggravating factors. You've heard a lot about the position from the victims, and obviously that this has had an emotional impact on the victims. Certainly that is something that the court may consider as an aggravating factor. Some of the mitigating factors that the court should take into consideration are those that we outlined in our sentencing memo. And I want to start off with probably the most important mitigating factor that this court should take into consideration, which is the age of Tyler at the time of these events. With regard to the counts that he has pled guilty to and have been included in the plea agreement, counts 5 and 6, Tyler was only 15 years old himself. During count 9, Tyler was only 16 years old. During count 14, he was only 16 years old. During count 26, he was 18 years old. He was a couple of months past his 18-month birthday or 18-year birthday. And the victim in that count, KG, was a freshman in his high school who was his girlfriend. For count 1 of the second indictment, he was only 16 years old at the time. So, of the offenses that he has pled guilty to, he was 15, 16, 16, and then a couple of months past his 18th birthday. That is quite significant for many reasons, Your Honor. And not only is it a statutory mitigating factor, but it is also a mitigating factor that the court should take into consideration based upon the vast literature that exists, that is peer-reviewed, about the recidivism rates of juvenile sex offenders. Now, I know that Your Honor has a background in juvenile cases, so you're probably familiar with these types of cases. You're probably familiar with much of the literature that was cited in the defendant's sentencing memorandum already. But some of the highlights from that literature, Your Honor, are the fact that based on the literature, The juvenile sex offenders are more likely motivated by experimentation, not deviations in arousal. That the juvenile sex offender is different than the adult sex offender. That the recidivism rates for juvenile sex offenders are only 7%, whereas they are over 13% for adult sex offenders. And there are risk predictors that may be present in juvenile sex offense cases that may increase the rates of recidivism or reoffending. And none of those factors are present here in this case. Deviant sexual interest. As the court knows, Tyler underwent a thorough battery of tests prior to the settlement conference, which was what we call a risk assessment. During that battery of tests, there was a clinical interview done. There were objective physiological tests that were performed that Tyler participated in. And ultimately, Dr. Garvey, in that report, concluded that Tyler is an extremely low risk to reoffend. So, Dr. Garvey also concluded that Tyler did not test on the scale of having any deviant sexual interest. So, this factor about whether Tyler is a risk to reoffend is not present. The next factor that may be present would be prior criminal sanctions for sexual offending. As the court pointed out at the beginning of this proceeding, Tyler has absolutely no criminal history of any kind. The next factor that may be present is sexual offending against a stranger. As the court knows from reviewing all of the facts that were included in the settlement conference memorandum and also the other pleadings throughout the case, none of the other persons in this case were strangers. These were all people that Tyler had known, that Tyler had dated, that Tyler was in a relationship with, or at least was friends with in some form or fashion. So that factor is also not present. Finally, there is a factor, or I shouldn't say finally, but there's also a factor of failure to participate in specialized treatment for sexual offending. As the court knows, Tyler has agreed to be placed onto a 15-year term of probation, which will include sex offender terms, and under those sex offender terms, that will include counseling. So Tyler is going to be able to participate as soon as he's placed onto probation in sex offender counseling, which will alleviate that factor. And finally, social isolation. Well, Your Honor, you've read dozens of letters that have been submitted on Tyler's behalf. You've heard from the family and friends here today, and we have a whole side of the courtroom here today that shows that Tyler is not socially isolated. He has significant family and community support, so that factor is also not present. So not only is age a factor statutorily that the court should be taking into consideration, but also based upon the research involved in juvenile sex offenders, I think that this court should give significant weight to that mitigating factor being present here in this case, Your Honor. The next mitigating factor that we ask the court take into consideration would be, I touched on it briefly, the favorable risk assessment that Tyler participated in. Dr. Garvey performed a clinical interview, a polygraph exam, a Millon clinical multi-axial inventory for the ABLE assessment, the ABLE questionnaire, the STAT-99R. And after conducting all of those tests, Dr. Garvey had an opinion and conclusions in which he stated that Tyler does not have any pedophilic sexual interest. He does not meet the criteria or diagnosis for paraphilic disorder. The sexual interests are in developed females. He does not have a diagnosis for a mental disorder or a mood disorder. And finally, she indicated that he is a very low risk to reoffend, and basically put his risk to reoffend the same as the literature puts for juveniles, which is 7.9%. So that is a second thing that we ask that the court take into consideration as a significant mitigating factor. His age, the peer-reviewed literature on juvenile sex offenders, and then, in addition to that, the fact that he has undergone a risk assessment personally and the very favorable conclusions from that risk assessment. The next mitigating factor that we ask the court take into consideration would be the strong family and community support. That is also a statutory mitigating factor, and I think in this case it's pretty overwhelming based upon all of the character letters that we provided to the court and also the support that he has from family and friends and community here in this courtroom today. We submitted, as the court knows, dozens of letters to the sentencing memorandum that the court has taken the opportunity to review. The next factor that we believe is a mitigating factor that we ask the court to consider in this case would be both Tyler's behavior while released on bond, as well as his behavior while he's been in custody. Jim read a letter to you and described an anecdote from when Tyler was in custody that I think is quite important. But even aside from that, we have attached dozens of certificates to our sentencing memorandum that show how active he was while in custody in Pinal County Jail over the last 3 years, or nearly 3 years, in being proactive, in participating in any and every class or educational program that they had to offer. Some of them kind of off the wall, others that I think will have a significant benefit for him personally in this case. But I think what it shows, Your Honor, is it shows that Tyler is a very young man who is in need of education further than what he's already received, both in the ways of academics as well as in life. And his being proactive in seeking out those educational programs while in custody is a very good indication that he is going to seek out any and all opportunities that the probation department has to offer once he gets out and gets onto probation. That's going to be critical for him moving forward, and I think that his willingness to participate in that while in custody, on his own volition, not court ordered, not court mandated, but on his own volition, shows significant evidence that he's going to perform very well on probation in this case, Your Honor. Also, as I indicated before, as this court knows well, there was a lot of litigation about whether Tyler should be held in custody while this case was pending or not. There was an original Simpson hearing. In fact, there was 2 Simpson hearings. Then when the Court of Appeals case came out, we had another Simpson 2 hearing. In fact, the Simpson 2 ruling came out from the Supreme Court yesterday that certainly would have potentially changed his custody status had that ruling come down previous to yesterday. But the point is that there was a time for about 30 days, approximately, when this court puts responsibility on Tyler and put the confidence in Tyler to release him to the community under conditions. And he took that opportunity and he performed perfectly. There were conditions on his GPS monitor. There was conditions on where he could go, where he could live, that he could not have any access to devices or the internet. The pre-sentence or the probation department monitored him during that time, and there were 0 violations or issues that he had during that time. And I just want to point out how significant that is, because what we're really deciding here today is whether Tyler is going to be released from custody very soon, or whether he's going to spend additional time incarcerated before he gets released onto probation. And one of the things that the court certainly has to take into consideration when making that decision is this person a risk to the community if they are released? And I think that his behavior during that 30 days and his willingness and ability to follow every condition placed on him to a T should alleviate any of the concerns that the court may have about whether Tyler is going to be a risk to anybody in the community. So that is another mitigating factor that we ask that the court take into consideration. And then finally, Your Honor, the mitigating factor that we also ask the court to take into consideration would be the pre-sentence report. The probation department in this case took a look at all of the police reports. They took a look at all of the information available in this case. They interviewed Tyler. I was present for that interview. And ultimately, they came up with a recommendation based on their offender screening tool that they used. And their offender screening tool indicated that there are no salient issues that have been identified for Tyler at this time. They recommended that, as to counts 14 and 26, the defendant be sentenced to the maximum term of 3 years imprisonment in the Arizona Department of Corrections to be served concurrently with one another. And as we indicated earlier, the maximum term is essentially the floor based upon the stipulations of the parties. So it's not only the defense's recommendation here today that Tyler be sentenced to the 3 years in prison per count joined concurrently with each other, but that is also the recommendation of the Pinal County Adult Probation Department, who was an objective body that took a look at all of the circumstances surrounding this case and made their recommendation for Your Honor to take into consideration here today. Just one final point I'd like to make with regard to the sentence would be that I think it's also a significant mitigating factor that Tyler has spent so much pre-incarceration in the county jail. As we know on our side, as I'm sure the state would agree, and as I assume Your Honor knows, the difference between time in the county jail, whether it's Pinal County or Maricopa County, versus time in the Arizona Department of Corrections is quite different. Time in the county jail is a very difficult time. And that is time that Tyler spent months after his 18th birthday when he was bucked out of high school and still a rather immature person. And he spent nearly 3 years of his very formidable years from 18 to 21 in the Pinal County Jail. That is a very difficult and many would say punitive result for anyone to have. And I do think that that warrants some consideration by this court, that perhaps a day in the county jail is not the equivalent of a day in the Department of Corrections, where certainly the conditions are better, quite frankly. So that's something I would ask the court to take into consideration as well. In the end, Your Honor, as I said, this is not a mini trial. This is a consideration for you to make about the aggravating factors that are present and the mitigating factors, and how those fit into the stipulations that the parties have reached in the plea agreement. Keeping in mind that the plea agreement and the stipulations that the party reached took into consideration all of the facts in the case, all of the allegations in the case, and a lot of information from the defense that we're not going to go into here this morning as well. And I ask that the court take those mitigating factors into consideration and conclude that the aggravated term of 3 years in prison is adequate, and that the aggravation is not so significant to outweigh the mitigation to warrant the super aggravated term of 3.75 years. I would also ask that the court run those 2 3-year maximum terms concurrently in line with the probation department's recommendation for that same reason, taking into consideration that at this point, based on the time that he spent in incarceration, the best thing for Tyler, the best thing for the victims, the best thing for the community as a whole is not additional punitive prison, but rather released back into the community so he can be placed onto probation, which will be heavily supervised, so that he can start availing himself of the programs and the education that the probation department will have to offer him for the next 15 years. So that's what we ask from this court here today. We also ask that the court give him credit for the 990 days of pre-sentence incarceration that he has spent towards that 3-year term. We ask that the courts waive the term of community supervision based upon the fact that he's being placed onto probation for 15 years in the other counts, that the court imposed the sex offender registration as we stipulated to in the plea agreement on counts 9, Your Honor, on the probation counts specifically, but not on the counts for which he is being sentenced to prison, so that he may have the opportunity to complete probation successfully and have that registration lifted, which, as the court described it, the ultimate carrot for him to perform well on probation. And finally, Your Honor, we ask that the court include in its sentencing minute entry that Tyler have unrestricted contact with his brother, who is still a minor, so that he may return home and live with his parents. Probation has already gone to his parents' home. They've already screened his parents' home as being appropriate for him to return on the probation once he's released. And the only issue there would be the fact that his brother lives there as a minor, so we certainly would ask that the court include in a minute entry that he has permission to have contact with his brother. And with that, Your Honor, I will let my colleague make some statements as well.
Mr. Kost, address the court briefly.
Yes.
Are you okay here, Judge?
This one.
I'm going to state my name, Your Honor.
Okay, Mr. Kost.
Tyler Kost. Your Honor, I want to apologize for my actions. I know that I made some serious mistakes, and I want you to know that I accept responsibility for what I did. I'm so sorry for the pain I caused everyone. I spent most of the last 3 years in jail thinking about what happened and the damage I've done. I lost a grandfather and so many other occasions with my family that we will never get back. I'm hopeful that the court will give me the opportunity to prove that I have matured and will never repeat my past mistakes. I took every class I could while in jail, and I'm looking forward to participating in every program offered by probation to continue to better myself.
Mr. Henry, do you have some comments?
Thank you, Your Honor. It struck me listening to victims' representatives, other folks, parts of this council get up and speak to this court, how very difficult it is to be in your position. As you come up and you hear the raw emotion pour out from the folks who have been involved in this case for the last several years, as you hear that from the family for Tyler, and I understand it's an extremely difficult decision. It's also very difficult, as you know, for the parties, for counsel, to address that emotion. But we know that we're not here today about emotion. We're here today about the facts. We're here today about what's the appropriate action for the court to take based on the facts. We also know, Your Honor, that while we as defense attorneys have to accept and have to validate the perceptions and the emotions that people feel and the anger that they feel and the upset that they feel, that we also have to point out when those emotions are not lining up with reality. And I still have to tell the court that even today, there are emotions and there are perceptions that are not lining up with reality, and things that have been presented to you today that are heartfelt. And I'm not telling you that those folks are saying them maliciously or intentionally to mislead you, but they're simply not accurate. Some of the things that I want to point out to the court, you had a young lady stand up before you and say that Tyler has been convicted for forcibly raping her. He has not. That's not what we're here for today. That is her perception, that is her emotion, but at no point did he ever admit to forcibly raping anyone. The state was in agreement with us at that plea agreement, and that simply did not happen. I appreciate the emotion, and we Understand that. But that is not a factor for this court to take into consideration. It simply is not an issue for this court. You also heard a lot of anxiety and emotion that I think was very valid about how these folks have felt their names, their lives dragged through the mud for the last 3 years. We acknowledge that Tyler is responsible for what he did. But at no point did Tyler, his family, or the defense call the press and say, let's talk about these people. There were press conferences. There was in particular a press conference that was called where all of this was aired out, where all of these people's anguish and fear and concerns were raised and were dragged out in front of everybody. And that responsibility doesn't rest here. That was done by others for their purposes, not for this case. So what I would tell your court, or tell this court, is that while Tyler accepts what he did, he does, and he is sorry for that. And we understand the anger and the concern that you folks have. We did not drag this into the media. We did not have you concerned of going through your daily lives. We certainly didn't do the things to cause Tyler's family to face death threats and to have this go out around the world, literally around the world. What I would tell the court is that the 3 years and the unceasing media attention would never have happened in this case, but for the actions of others, not the victims, not Tyler, and not his family. And so much of the anguish and the emotion that you are hearing today has been caused by that media. You heard one of the individuals get up and address you and say, every time an article came out, I lived in paranoia. Yes, I understand that. And Tyler's family lived through that same thing. Again, while paying respect and understanding to some of the folks that would speak and did speak to you, I want to point out again some differences, Your Honor. You heard from a young lady that spoke to you that said, this is what happened to me. I was forcibly raped, and it was a horrible, horrible nightmare for me. Your Honor, you have the information that was initially provided 3 years ago to the police, and that is not what was told to them. I would submit to you, Judge, that after 3 years of unceasing media and the anguish of having this thing hang over their heads, that folks' perceptions are dramatically different today than they were when this case started 3 years ago. You heard a statement read from one of the victims who talked about, again, the horror that this put her through. Judge, that victim, KG, came to court to testify on Tyler's behalf at one of the initial appearances. It never went forward on that day, and so you never heard from her. Actually, you weren't on the case at that time. But this is somebody who actually reached out after the charges to the defense team to say, you know, I'm here to help. Who told us not only was she not forcibly raped, but she had never had sex with Tyler, who now, 3 years later, and millions of media stories later, is now saying a different story. I say this, Your Honor, because I think many people think, well, why are these deals done? When you hear the emotion, when you hear the fear and the anger that comes out from victims, why would anybody agree to this sort of a case? Folks need to know that these sorts of results are reached because when you start looking into the facts of these cases, they are much more complex than they appear just in a story. We today have vast differences, not just of opinion, but of beliefs about the facts with the prosecution. We acknowledge that. those differences have to be resolved one way or the other. It either goes to trial or it reaches a resolution like this, and that's what we've reached. And frankly, I don't think either side is happy with the process or how we got here. But what I can say is I have to agree with my colleagues on the other side that this is the best result for all parties here. I want to talk about punishment for a second, Your Honor. You have to determine what the punishment is here. You have to determine, quite frankly, should Tyler spend some additional time in prison, or is the time that he spent for the last 3 years sufficient for the interests of justice to be served? There are really, Your Honor, just two reasons to put somebody in prison. One is to punish them, and the other is to ensure that they're rehabilitated. There is absolutely nothing about rehabilitation that will be served any further than the 3 years that Tyler has already spent. When it comes to punishment, I would ask the court to understand what you did not hear. You did not hear the prosecutors asking that Tyler spend additional time in prison. You did not hear the probation department asking that Tyler spend additional time in prison. With rare exceptions, you did not hear any victim statements, or any of the individuals from dismissed counts asking that Tyler spend more time in prison. You heard a significant amount of anguish. We acknowledge that. Tyler acknowledges that. But when it comes to punishment, this is a young man who has spent 3 years essentially in custody, and who has been punished over and over and over. When you look at punishment, Judge, sometimes you also have to look at proportionality. And one of the issues here is that Tyler is in a completely different situation than probably anybody else this court is dealing with for the last 3 years and beyond. No matter what happens after this, when somebody enters Tyler Kost's name in the internet, it's always going to come up with that famous statement that was made in a press conference, serial rapist. Even though he has not pled guilty to a single count of rape or sexual assault, that will always be the tag on his name for the rest of his life. That will be the tag that follows around his parents, his brother, and everybody in his family. That is so far out of proportion to the things that other people will go through for similar acts that I think the court needs to take that into consideration. Another thing that this court did not hear is aggravators. So it's important to know that the sentence that was agreed to is already an aggravated sentence. And to move that to the maximum aggravated sentence, as we talked about earlier, this court would have to find multiple aggravators and would have to find that they are outweighing the mitigation that's been presented to this court. I would submit that that's just not here. You did not hear somebody get up. You certainly didn't hear the state get up and talk about multiple aggravating factors. And they certainly didn't talk about those factors outweighing the mitigation that's been presented. I would ask this court to look at all of the things that have happened in this case, all of the information that's been provided to you, Judge, and to follow the recommendations of the probation department, the recommendations you saw in the report from Dr. Darby, the requests that we've made, and frankly, to understand the liberty that the court has been given by nobody making a recommendation for him to do any additional time in prison. The reality is, Your Honor, Tyler's likelihood to reoffend is as close to zero as it can be for anybody. He will be closely monitored. I heard Mr. Ginsburg raise a concern, and it's a legitimate concern to say, well, the law allows him to terminate at 22. That has never been on anybody's radar. Is that we leave here and 11 months later, he comes in and moves to terminate under the statute. It just hasn't been. It's never been discussed. It's never been raised. And so that's not an issue for us, not an issue for Mr. Kost. He understands that if he's allowed to terminate prior to 15 years, that will be something that he has to earn, and he has to show the court that it's not even a consideration for him now. He also understands, Your Honor, that if he violates probation, this court has an enormous hammer to hold over his head to put him back into prison. And I would ask the court to take into consideration that with all of the monitoring available, with all of the supervision that he's going to be getting, and the threat of ongoing prison hanging over his head, that Tyler is not going to slip up, he's not going to reoffend, he's not going to be here again, other than if this court needs him to come in and report, or if there's something that we need to notify the court about for any reason. He's just not going to be here. He's got family, he's got friends who are going to watch him, who are going to monitor him, and who can do everything they can to make sure there are no issues for this court. We're also asking the court to allow him to return to his home. And in order to do that, this court has to make a finding that he's allowed to be around his own brother, who's under the age of 18. And we're asking the court to do that. That will, again, having a younger brother, that will again put another sense of responsibility on Tyler. He failed his family badly, and he feels that deeply. But those failings were the failings of a juvenile. Some of the things that were put before you started when he was 13, and then 14, and then 15. And one count is from a short period of time after he turned 18. Your Honor, Tyler Kost will not give you cause to violate his probation, or will not give you cause to regret allowing him to return home, getting credit for the time that he has served, and giving him a 3-year sentence for prison. We're asking that for the other things that Mr. Allen asked for. We're asking that he be given the ability after 3 long years to go home. Thank you, Judge.
Mr. Kost, could you stand? Mr. Kost, based on your guilty plea of prior proceedings, it's the judgment of the court that you were guilty in CR 2014-00949 to first, amended count 5, attempted sexual conduct with a minor, a class 3 felony, and dangerous crime against children in the 2nd degree, committed between January 6, 2011 and June 30, 2011, in violation of the statutes listed in the plea agreement. It's further the judgment of the court that you were guilty of amended count 6, again, attempted sexual conduct with a minor, a class 3 felony, and dangerous crime against children in the 2nd degree, with an offense date, again, between January 6, 2011 and June 30, 2011. Based on your guilty plea, at the time of the change of plea, it's further the judgment of the court that you were guilty of amended count 9, child abuse, a class 4 felony, that occurred on or between February 1, 2012 and February 29, 2012. It's further the judgment of the court based on your guilty plea that you were guilty of amended count 14, child abuse, a class 4 felony, that occurred on November 6, 2012. Finally, in CR 2014-00949 is the judgment of the court based on your guilty plea that you were guilty of amended count 26, child abuse, a class 4 felony, with an offense date between March 1, 2014 and March 31, 2014. In CR 2014-01054, based on your guilty plea in that case, it's the judgment of the court that you were guilty of amended count 1, attempted sexual conduct with a minor, again, a class 3 felony, dangerous crime against children in the 2nd degree. The offense date is between November 28, 2011 and November 27, 2012. Each of these offenses are in violation of statutes listed respectively for each count in the plea agreement. You pled to each of these offenses as non-dangerous, non-repetitive offenses under Arizona law. All counts identified for dismissal in the plea agreement are hereby dismissed. As I indicated, I've had the opportunity to review the facts in this case in depth. I believe the plea agreement is ultimately appropriate, even though I suspect neither side is satisfied with it, and understandably so. I want to address first counts 14 and 26, the two counts in the plea agreement call for a prison term. To be sure, yes, defense has argued here there are mitigating factors in this case that are substantial. Your young age at the time of these offenses is a substantial mitigating factor. The fact that this is your first involvement in the criminal justice system and the fact that you have no prior involvement in the juvenile justice system is also a substantial mitigating factor. The court also finds that the favorable psychophysiological risk assessment performed by Dr. Clarity, as well as the favorable criminogenic risk assessment performed by adult probation, are mitigating as well. And we also consider the other mitigating factors the defendant raised in their sentencing. The plea agreement, as has been discussed here, provides for a range of sentence between the maximum sentence of 3 years and the aggravated maximum of 3.75 for each of these counts. And the law tasks the court with the responsibility of weighing mitigating factors against the aggravating factors, and as I have signaled, I intend to follow the terms of the plea agreement. There are aggravating factors in this case. They are substantial. We have seen it here today. Any suggestion that the emotion of the victims here today was insignificant is not accurate. It's not accurate legally, because an aggravating factor the court can consider is the emotional and mental harm to the victims. And that today is palpable. And it was great. The court finds the mental and emotional harm to the victims is a substantial aggravating factor in this case. The court also finds as an aggravating factor that these offenses are not isolated incidents. They're part of a series of repetitive, similar criminal acts involving multiple victims, which have resulted in criminal convictions today. My task is to weigh the mitigating factors, which are substantial, and the aggravating factors, which are also substantial. It is a difficult task. But I do want to make sure that the victims do not feel that I share what may have been suggested by the defense here, that your emotions don't matter. I want to validate that. It does matter. And I found a substantial aggravating factor here today based on what you said. Balancing the mitigating and aggravating factors here together, I ultimately come up with a balance that you should be sentenced to a maximum term, the aggravated maximum, with the maximum prison term of 3 years in the Department of Corrections on each of these counts. The issue of whether the offenses should be concurrent or consecutive, that is a difficult issue. I consider the fact that these offenses involve separate victims and they were committed on separate occasions. And I considered the compelling input of the victims here today. Against that, in this determination of whether the offenses should be concurrent or consecutive, I have considered several other factors. So I considered the recommendation of the Adult Probation Department in the pre-sentence report that the sentences in this case should be served concurrently. I have again, and rightfully so, considered a young age at the time of these offenses. I have also again considered the fact that this is your first involvement in the criminal justice system, and there's been no prior involvement in the juvenile justice system either, and this will be the first effort to have intervention on behalf of the criminal justice system. And perhaps most significantly, I considered the fact that this plea agreement, rightfully so, provides that you shall be sentenced to 15 years of probation on 4 separate counts, which will, by the terms of the plea agreement, run consecutive to the prison terms imposed on counts 14 and 26. And that as a consequence of that, if you ever violate your probation, you will be looking at a prison sentence of up to near 50 years in the Department of Corrections. And I further considered, in light of the significant restrictions that will be imposed through probation, including sex offender terms, computer terms, and registration as a sex offender, that this will carry with it a long-term punitive effect in itself. Ultimately, I'm convinced, based on these circumstances, that these sentences should run concurrent with each other. Based on that, it is the judgment of the court that you will receive credit for 990 days of pre-sentence incarceration, credit towards that prison sentence. By law, pursuant to ARS 13604.04, you are eligible to receive earned release credits. Moving on to the other counts, that would be count 5, count 6, count 9, and CR 2014-00949, and count 1 and CR 2014-01054. Consistent with the terms of the plea agreement, it's the judgment of the court that imposition of sentence should be suspended on those counts, and that you should be placed on probation consecutive to the prison terms as opposed to today on counts 14 and counts 26. Your terms and conditions of probation will be the rules you have to follow. You'll need to review them and sign for them before you leave here today. I do want to review some of those terms with you. Standard terms number 1 through 15 will apply. Term number 3 will provide that you are not to leave your county or your residence without the permission of your probation officer. Term number 16 will provide that you are not to consume any substance containing alcohol at all. Term number 18 will provide that you shall be incarcerated in the county jail I'm sorry, I'm not going to follow the recommended term number 18 in the circumstances here. Term number 19 will provide that you're not to have any contact with the victims whatsoever unless it's approved in writing by the Adult Probation Department. Term 20 will provide that you are to complete up to 100 hours of discretionary community restitution as directed by the Adult Probation Department. Term number 21, as I telegraphed earlier, will provide that you are to abide by the special conditions of probation for sex offenders and computer conditions. Term number 22 will provide that you are to register as a sex offender as defined by law and address that further. Term 22 will also provide that you are not to possess or consume any synthetic drug or mind-altering substance. That same term will also provide that you are to appear at a review hearing on September 8, 2017, in order for the court to determine if GPS monitoring pursuant to ARS 13902G is appropriate. Term number 15 will provide that you are to pay a monthly probation supervision fee of $75. In addition, you'll be required to pay a $250 sex offender registration assessment payable in monthly increments of $25. The first payment will be on the first day of the third month following your release from prison in the amount of $100. No claim for restitution has been submitted that I am aware of at this time. Mr. Ginsburg, Mr. Burley.
Your Honor, there is a potential of at least one claim that we're aware of that the court would be willing to leave that open for 90 days. We can have that filed.
The court will reserve jurisdiction for 90 days from today's date to consider any claims for restitution that may be submitted by the victims or consider any requests to extend that time for the caution. I do is a standard term of sex offender conditions that a defendant not have contact with any persons under the age of 18 and not residing with anyone under the age of 18. In this circumstance, and given the nature of the offense's psychosexual evaluation, I am going to provide the sex offender terms that shall not apply, at least initially, to the defendant's brother, so that he may reside with his brother. Certainly, if probation identifies any issues in the course of supervision of Mr. Kost, then that term can be modified to remove that provision that he can't have contact with his brother. Based on the fact that the court is imposing consecutive terms of probation for 15 years, and that will be consecutive to counts 14 and counts 26, the prison terms on those counts. The court will waive the requirement of community supervision in light of the fact that you'll be much more stringent probation supervision at that point, frankly. On counts 5, 6, and 9 in CR 2014-00949 and count 1 in CR 2014-01054. On the issue of registration, it is ordered that the defendant shall register as a sex offender for counts 5 and 6 in CR 2014-00949 and for amended count 1 in CR 2014-01054. This requirement may terminate after a hearing pursuant to ARS 13-3821 and ARS 13-923. Consistent with the terms of the plea agreement, the requirement to register shall terminate upon successful completion of probation if it is not terminated earlier pursuant to ARS 13-923 or ARS 13-3821. Consistent with the recommendations of the state and the defense, the defendant shall not be required to register as a sex offender for count 9 and count 14 and count 26. Mr. Kost, my decision today, as I've indicated, to run these prison sentences concurrent is based in large part on the fact that you will be placed on supervised probation for a very, very long time under very strict conditions. I understand that there has been a suggestion today that the court should consider good character as a mitigating factor. I have not been persuaded up to this point. That is a genuine mitigating factor. I do believe, based on psychosexual risk assessment and risk assessment performed on probation, that you are candidate who can succeed on probation. And I hope you appreciate how important it is to understand all those rules and to follow them to the letter, because the potential consequences if you violate them to probation are great. You understand this?
Yes, sir.
All right. Do you, counsel, have any questions about the sentence imposed or the terms and conditions of probation before I go over post-conviction other crimes?
Only, Your Honor, I'm not sure if you made a note whether or not each of the probation terms are concurrent with each other.
I don't think I said that expressly. So, 4 counts. So your counts 5, 6, and 9 in CR 2014-00949, and count 1 in CR 2014-01054 shall run concurrent with one another but consecutive to the prison terms imposed on counts 14 and 26. Any other clarification requested by either counsel?
No, Your Honor.
Mr. Kost, you do have the right to petition this court for post-conviction relief if you believe any errors have occurred. If you want to do that, you have to file a notice of post-conviction relief within 90 days from today's date. If you don't file that notice within that time frame, you may give up your right to seek post-conviction relief on some grounds for once and for all. You do have the right to be represented by counsel in those post-conviction relief proceedings and to be represented free of cost if you can't afford to hire an attorney. In that event, you would also have the right to have records and transcripts from these proceedings copied for you free of cost to assist you in that process. Do you have any questions about your post-conviction relief rights here today?
No, sir.
Either counsel have anything further before we break?
Not even state, Your Honor. Not to go to the sense.
All counsel